Thanks everyone for joining us this afternoon for PLP's latest Law with Lunch. I hope you've all managed to grab a sandwich and a coffee to settle down to what will probably be about 40 minutes. I'm going to take the first half and then Bharat will take over for the second half. And as you're aware, we are going to speak to you about the updates in employment law legislation. So looking at what you might have missed, hopefully not, what we are expecting in the next really a couple of weeks, and also looking forward to later on in 2024, perhaps moving into 2025 as well. As you are probably all aware, there's quite a lot going on in 2024 when it comes to employment legislation. We don't have a huge amount of time today, so we're not going to go into all of the legislation in a significant amount of detail. This is really aimed at gathering all the changes that have been and are expected together into one seminar, a bit of an aid memoir for you, for as and when you come across something in your practice. Hopefully what Bharat and I have said to you today will at least trigger something in your memory to go back and check what the latest acts or regulations say. So it is, I'm afraid, going to be a bit of a quick canter through the various changes, but we'll touch on what we think are the main points in relation to each of those. So looking at briefly at the outline and what we're going to deal with, what you might have missed, it's in force already. The rather snappily entitled the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. There is another aspect that we're going to turn to, which is the Equality Act 2010 Amendment Regulations. Although that's appearing relatively early in our outline, actually Bharat's going to deal with that slightly out of turn a little bit later on. So then once we've touched on that, I'm going to come on to some changes that we're going to see in the very near future. We've got 5 listed there. I'm going to deal with the first 4, starting with the Protection from Redundancy Act, looking at the Employment Relations, Flexible Working Act, as well as the Flexible Working Regulations, and then the Carers Leave Act and the Carers Leave Regulations. And thereafter, Bharat is going to take over and take you through to finish. And he'll be looking at some future changes which are set out there: the Worker Protection Act, the Predictable Terms and Conditions Act, and the Neonatal Care Act as well. So, as I say, I'm going to start with the Amendment, Revocation and Transitional Provision Regulations 2023. Really 3 main issues there that I'm going to touch on. Firstly, holiday pay, which is probably the one you've heard most about, if anything, but also there are regulations in relation to TUPE and the working time regulations, record keeping. As I said earlier, it is in force already, came into force on the 1st of January 2024. Albeit that not everything is in motion right now, and I'll come on to that. So, dealing with holiday pay first, the regulations deal with largely, but not exclusively, irregular hours and part-year workers. And in relation to those workers, the regulations apply for leave years beginning the 1st of April 2024. So when they apply to which individual workers depends on when their leave years start. Could be as early as 1st of April 2024. What the regulations do not do is that they do not touch on and address the issue of the 2 separate types of holiday pay, the statutory, the first 4 weeks and the 1.6 weeks thereafter, those issues that were discussed in Agnew. It doesn't deal with that, but the regulations do deal with the Harper, Trust and Brazel Supreme Court judgment from 2022. Most of you, if not all of you, probably remember that judgment, and at least remember the broad outline of it. Prior to that judgment, it's probably fair to say that a lot of employers were calculating holiday pay for irregular hours and part-year workers by using the 12.07% of hours worked. As you may or may not recall, the Supreme Court said in Brazil that that's not the right way of doing it. And instead, what we have to do is look at the number of hours worked in a reference period, but excluding those weeks in which no work was undertaken. What that did is probably slightly skew in favour of those workers the holiday pay that they were entitled to, because it wasn't prorated. But that's what the Supreme Court said, and it led to a bit of panic among some employers. Some have since changed their practices. Others perhaps have held off in view of what were thought to be impending, or what was thought to be impending legislation. And that legislation is now here in the form of these regulations. So the regulations effectively reverse the Brazil case and take us back to where we were, and entitles employers to look at it on a 12.07% of hours worked during a particular period. And what we don't have to do is exclude those weeks not worked. So that's probably what you've heard most about, but there are some other aspects of holiday pay in these regulations. I've set them out there. Rolled up holiday pay is permitted. Holiday pay calculations must include matters or payments such as intrinsically linked commission payments, overtime that's regularly paid. That's in relation to the statutory, the 4 weeks. But it really puts on a statutory footing what we probably already knew. But also the final bullet point, these regulations deal with carryover of leave. And this aspect of the regulations is already in force. And what it says is that workers can carry over up to 28 days of leave if they have been unable to take that leave because of maternity and other family-related leave. The regulations also say if you are unable to take leave because you have been on sick leave, you can carry over up to 20 days. And there are also some provisions in there in relation to where leave hasn't been taken through effectively the fault of the employer. So, for example, a failure to acknowledge that someone has a right to annual leave. Moving on, in terms of the regulations and other issues, TUPE is one aspect. These are transfers on or after the 1st of July 2024. And what the position was, or still is until that point, is that if it's effectively a micro business with fewer than 10 employees, there's no need to consult with employee representatives. Well, this widens the scope. You'll see there that where the employer employs fewer than 50, or the transfer involves fewer than 10 transferring employees, then as long as there's no representative in place and the employer hasn't already invited employees to elect representatives, then they can inform and consult directly with those employees as if they are representatives. And finally, there, record keeping. Employers must keep records which are adequate to show that the employer has complied with the WTR. So what they don't have to do, or what there isn't a requirement for, is to keep a full record of all daily working hours, so long as the employer can otherwise, in any event, show that they have complied with the WTR. Now, moving on, the Protection from Redundancy, Pregnancy and Family Leave Act 2023. You'll see on the left-hand side, where are we currently? Well, there are provisions in the ERA 96, various provisions set out there. This is in relation to redundancy and the right to be offered a suitable alternative vacancy if one is available. This Act probably targets really the rather unscrupulous employer who might wait until someone returns from whatever leave it may be, and then undergoes a redundancy process. Because what the Act does is set out that there is an additional protection period in relation to redundancies. So it's not just during those leave periods, but after those leave periods as well. Although the slide is entitled with the Act, it's actually the regulations which put the meat on the bones here. Over on the right-hand side, you'll see maternity leave, adoption leave, shared parental leave, amendment regulations 2024. So this is in force as of 6th of April 2024, essentially for leave periods which end on or after that date. And you'll see in the second half of the slide on the right-hand side, there is a significant additional period. Maternity, for example, 18 months from the child's date of birth or expected week of childbirth. And you can see that filter through, including, for example, shared parental leave. So if as little as 6 weeks continuous shared parental leave is taken, there's an additional protected period such that it's for 18 months from the date of from the child's date of birth. So quite a significant change there. Okay, Employment Relations Flexible Working Act 2023. This isn't in force yet. It by all accounts was expected to come into force on the 6th of April, but it requires regulations, and those regulations haven't been laid down yet. So it's not quite clear when this will come into effect, but it looks like it will at some point. So it's as well to get our heads around it at this stage. And this is all about flexible working requests. As we know, flexible working requests are dealt with in 80F and 80G of the Employment Rights Act. And there are a number of headlines from this Act which I think you ought to be aware of, whether you're advising employees on their own requests or advising employers as to how to deal with a request made by an employee. And the headlines are set out. Firstly, the number of applications. It was 1 every 12 months. It's now no more than 2 applications to the same employer during a 12-month period. The employee must be notified of the decision within 2 months. It was 3 months, it's now 2, and that still incorporates a decision on appeal if there is an appeal process. What the Act doesn't do, which we perhaps might have expected, is it doesn't give a statutory entitlement to an appeal on these decisions. But if an appeal process is undertaken, then it needs to be within this 2-month period. Third bullet point there, an application cannot be refused unless the employee has been consulted upon it. Now, as a matter of practice, a number of employers would consult with the employee, but there's no statutory requirement to do so. As it stands, it just has to be dealt with reasonably. So there we have set out that there has to be consultation with the employee. And finally, one worthy of note is that, and it relates to what we often call the business case. Employees aren't now going to be required to set out what effect that the change will have on the employer, and as it says there, how such change might be dealt with. So we might usually expect to see something from an employee, for example, saying, I want to go, I would like to work part-time, or I'd like to work a particular number of hours, and this is why it isn't going to affect you as the business. There's no longer going to be a requirement for that, as and when this comes into force. Along with the Act that I've just mentioned, we have the Flexible Working Amendment Regulations 2023. This one is nice and simple. We know it's coming into force. It's as of 6th of April 2024. And what it does is, as it says there, it revokes Reg 3 of the 2014 regulations. In a nutshell, there is no longer going to be a requirement for an employee to have 26 weeks continuous service before having a right to make a flexible working request. As of 6th of April, this is now going to be a day one right. In conjunction with that, we're expecting the a new ACAS Code of Practice to come into effect on the same day. So watch this space for that. Moving on to the last two elements that I'm going to deal with, Carers Leave Act 23 and the Carers Leave Regulations 24. They need to be looked at together, really, because again, the regulations put the meat on the bones, so to speak, of what's in the Carers Leave Act. So the Act itself is already in force. I'll come on to the regulations in a moment, but what it does, the Act requires regulations, which we're going to turn to, effectively entitling an employee to be absent from work on leave, as it says there, in order to provide or arrange care for a dependent with a long-term care need. What is a dependent? Well, spouse, civil partner, child, parent, someone who lives in the same household, or as it says there, someone who reasonably relies on the employee to provide or arrange care. So the third aspect is a little bit of a catch-all, perhaps might be interpreted reasonably widely. That, of course, remains to be seen. But the Act sets out, if you're unsure, go to the Act, because the Act sets out who counts, who qualifies as a dependent. In terms of long-term, it's not there on the slide, but the Act again sets out what is considered to be long-term. It's an illness or an injury that requires or is likely to require care for more than 3 months, or a dependent who has a disability, or where there is a dependent who has care needs for a reason connected to their old age. As it sets out there, you've got a right to, an employee has a right to complain to the tribunal if an employer unreasonably postpones the period of leave or has prevented or tried to prevent them from taking that leave. So I said I'll come on to it. The Carers Leave Regulations 24, as of 6th of April 2024. So it's where it's applicable once an employee gives notice of an intention to take that leave on or after the 6th of April 24. The entitlement is to 1 week of carers leave during any 12-month period. It has to be a minimum of half a day, but doesn't have to be on consecutive days. But there are some specific notice requirements on behalf of the employee and on behalf of the employer, actually, as we'll see. But dealing first with the employee must give notice, and it must specify their entitlement to take carers leave, and it must specify the number of days or part days that they are to take. And it must be given before the relevant date. And that's perhaps rather clumsily worded as the earlier of twice as many days as the number of days to be taken, or 3 days. So effectively a minimum, as I read it, a minimum of 3 days. If you're taking a day, you need to give 3 days notice. if you're taking 3 days, you need to give 6 days notice. It's set out in the regulations. That's my understanding of it. Now, an employer can postpone that carer's leave under the right circumstances. Fourth bullet point there, you can see it's set out. If the employer reasonably considers that the operation of their business would be unduly disrupted. But there are some caveats to that. The employer has to give notice to the employee. The employer has to agree another date for the employee to take that leave. So if an employee asks for, say, or requests 2 days leave, the employer has to, if it's postponing, agree when the employee can take those 2 days leave, give the employee notice of that, and that has to be within a month of the first day that they had originally intended to take that leave. The regulations also set out protection from detriment and from unfair dismissal in relation to carers' leave. It's regulations 11 and 12. Essentially, if the employee sought to take or made use of the benefits of carers' leave, and they have been treated detrimentally because of that, they have protection under Regulation 11, or dismissed, they have protection under Regulation 12. Or if the employer believed that the employee was likely to take the carer's leave. So, as I say, we can see there that there is protection from detriment and from unfair dismissal in relation to this leave of 1 week or up to 1 week as of 6th of April 2024. That is everything that I am going to deal with, and I'm going to hand over to Bharat.
Thank you, Tim. Am I on mute or not? Can you hear me? Wonderful. Thank you, Tim. Good afternoon, everyone. So what I'm first going to talk about is the Paternity Leave Amendment Regulations 2024. So these came into force on the 8th of March 2024, but only apply and only come into effect where the expected week of birth or the placement for adoption is on or after the 6th of April 24. Whereas before, paternity leave had either had to be taken as a continuous period, one continuous block, and that was either 1 week or 2 weeks traditionally. The new regulations allow this now to be split up. So you can still take the continuous period of 1 or 2 weeks, or there could be 2 non-consecutive periods of leave of a week each. So there could be a period of leave, a period of 1 week, a return to work, and then a further period of 1 week paternity leave. That period or those periods of leave can now also be taken within 52 weeks of the birth or the placement. So whereas before the leave had to have been taken within the first 2 months, effectively 56 days, there is now the extension that this applies, or the leave can be taken within the first 52 weeks. And the reason why the regulations came into force on the 8th of March is because the notice period itself has been reduced. So previously the notice period was 15 weeks, and now the notice is only 28 days. So obviously coming into force on the 8th of March, that gives 28 days notice for a leave period beginning on the 6th of April 2024. What hasn't changed is that the right and the benefit to paternity leave is still only accrued after 26 weeks continuous employment. So the basic right to have paternity leave, that is still 26 weeks. It's the notice period and how the leave is taken effectively that has changed, effectively giving those seeking to take paternity leave just greater flexibility in relation to that. Next is the Work Protection Amendment of the Equality Act 2010 Act that came in 2023. So it was passed in October 23 and takes effect 1 year after that. So it comes into force of October this year. It's an amendment to Section 40 of the Equality Act, so that where an employer must not harass an employee or someone who has applied for employment, it is now amended to also include that an employer must take reasonable steps to prevent sexual harassment of employees in the course of their employment. It only applies to sexual harassment. It doesn't apply to any other forms of harassment, say racial or religious harassment. So strictly sexual harassment only, and it isn't a standalone claim in and of itself. It's a bolt-on. So where an employment tribunal has found that there has been a contravention of Section 40, so there's been a finding of harassment to an employee, which involves to any extent an element of sexual harassment, and there has been an order that the respondent makes a payment of compensation to the employee, the tribunal then are to consider whether and to what extent the respondent has also contravened this new Section 40A. So whether and how they have contravened or whether they've taken reasonable steps to prevent that sexual harassment in the workplace. There isn't, there was previously the query as to whether an employer has to take all reasonable steps, but the word all was dropped in relation to the Act, and so it is just reasonable steps in and of its own. What actually amounts to reasonable steps is probably a good question, and one that isn't actually defined in the Act. The ECHR I believe are due to issue further guidance on this. I haven't been able to find that. Yes, I haven't been able to find a date when that's due to come out, but they have, which I was able to find, the January 2020 guidance, which already is in place, and that is to prevent, in general, harassment in the workplace. It does also refer to sexual harassment. As to what reasonable steps or steps that could be taken, it refers to having policies in place, making employees aware of those policies and providing training on those policies. It also refers to employers perhaps being proactive in detecting harassment, so discussion in one-to-one meetings, having check-ins with employees. These are all perhaps steps an employer could say that they have taken to prevent the sexual harassment in the workplace. And there's also consideration of risk factors in the workplace, such as considering power imbalances that may be or potentially there, and what employers potentially done to deal with those potential power imbalances. If a tribunal consider that the employer hasn't taken reasonable steps, they can then uplift compensation up to 25%. And what is interesting as well is that this is a must step, that they must uplift the compensation, and perhaps a point that doesn't necessarily need to be pleaded for it to take effect. So similar perhaps to a jurisdiction point, this is something that the tribunal of their own volition need to consider and need to take account of if there have been those previous findings of harassment related to sex in the workplace, and there's been an order for compensation. Moving on, we have the Workers' Predictable Terms and Conditions Act 2023. So where Tim had spoken previously of having the Act and the regulations providing the meat on the bones, currently we're still on the bones for this. So we are awaiting the regulations, and they're expected in September, October of this year. Similar to the flexible working request that Tim's already dealt with. And this applies to both workers and agency workers. For the agency workers, the request can be made to either the hirer or the temporary work agency. What is it? It's right to request predictable work pattern. So where there's unpredictability in the hours that the individual works, the days of the week on which they work, and the times on those days when they do work, the period for which the worker is contracted to work. And in relation to the regulation, well, the Act, it says, and such other aspects of the worker's terms and conditions of employment as the Secretary of State may specify by regulations. So it may not be limited to just the hours, dates, and the period contracted. That could be expanded by the Secretary of State. Whether they will or not is another question, but that is something to keep an eye out on. And as to the duration of work, so the period contracted, it could even mean an application or a request to extend a fixed term contract, that is for 12 months or less. The applicant can make no more than 2 applications in the 12-month period. They can't make a new application when an application is already being considered. And the employer must also deal with the application in a reasonable manner and only reject it for one of the specified reasons. Those include the burden of additional costs, the detrimental effect on ability to meet customer demand, the detrimental impact on the recruitment of staff, the insufficiency of work during the periods the worker proposes to work, and planned structural changes. So those are the listed rejections. But then again, also includes and such other grounds as the Secretary of State may specify by the regulations. So perhaps a quite wide ambit that the employer has in rejecting a request. When considering a request, there's a 1-month decision period, and if there's any offer of new terms and conditions, those need to be provided within 2 weeks of the application being granted. The Act does provide the right to bring an ET claim if, for example, the employer has failed to deal with the application properly, or among reasons that the employer's decision was based on incorrect factors. So even if perhaps an employer provides a rejection, there may still need to be some consideration and production of real evidence, if there was a tribunal claim, as to why that rejection took place and why that reason is the reason they decided. The time limit for bringing such a claim would be 3 months, and it's the reasonably practicable test for any extension. So keep an eye out for the regulations. The final version may be slightly different to what is here mentioned in this presentation. So hopefully we'll have a clearer picture when the regulations come out. The next piece I'm going to deal with is Neonatal Care Leave and Pay Act 2023. So again, we've got the bones, awaiting the meat, awaiting the regulations. So the Act creates a statutory entitlement to neonatal care and neonatal care pay. So there's this statutory creation of those 2 points. As to the leave, it must be taken before the end of period of at least 68 weeks, beginning with the date of the child's birth. So, within 68 weeks, effectively. Again, perhaps statutory language as to making it perhaps more clumsily worded than it perhaps could have been. And the entitlement to the leave is of at least 1 week. So it's yet to be seen whether the leave would be provided for more than 1 week. We'll have to wait and see. The entitlement is only if the neonatal care continues without interruption for at least 7 days. But the Act also says that the regulations may specify the circumstances where neonatal care is to be regarded as continuous despite an interruption. So, as to continuous period without interruption for 7 days, it may include an interruption within those 7 days within a wider period. Neonatal care itself has been defined as a medical or palliative care that starts before the end of the period of 28 days after the child's birth, so within 28 days, and its care as to that definition, though, the regulations could also specify a kind of care by reference to the kind of place at which care is provided. So whether that's reference to a neonatal care unit or the type of hospital the child is at, or whether they refer to particular wards or the types of care provided. So it isn't not only is it the type of care that's provided, but it's where that care is also provided. There's the right to statutory natal care pay is subject to 20 weeks service, so similar to the paternity pay and maternity pay and minimum earnings regulations. You cannot contract out of the only neonatal care pay, and any contractual point in relation to this would be considered void. Also, as a general update, we have new minimum wage and living wage rates that come into force from the 1st of April 2024. So previously, for those who were 23 and over, they were given the minimum, it wasn't only the minimum, it was the living wage that they had, £10.42 from the 1st of April 2023. But from the 1st of April 24, it is those who are aged 21 and over who are entitled to the national living wage as their minimum wage. And so, as you can see, from the 1st of April, both for those 21 and over, national living wage at £11.44 applies. And for those 18 to 20 under 18 and apprentices, those are the new rates on screen, as you can see, from the 1st of April. From the 6th of April, we have the increase to the statutory rate of sick pay. So that'll now be £116.75 per week. And then also the statutory maternity, paternity, adoption, shared parental and bereavement pay increase, which I imagine will also include now the neonatal care, which will now be £184.03 per week. As Tim mentioned, we're looking finally at the Equality Act amendment regulations. So these are just some highlights and points that I thought were quite interesting. So there are some wider amendments that have been made in relation to the regulations that aren't covered in this slide, and that include that employers are liable for conduct equivalent to direct discrimination if a discriminatory statement is made regarding recruitment. And there's definitions as to how that applies in that recruitment process, even if there's not an active recruitment process underway. And that also, in relation to the purpose of equal pay claims, an employee is entitled to draw a comparison with another employee where the terms are attributable to a single body responsible for setting or continuing the pay inequality, and which can restore equal treatment, or where their terms are governed by the same collective agreement. So those are 2 points not mentioned in the slides. What these regulations do are just to bring the statutory law up to date with recent decisions. I say recent, but decisions of the ECHR and the ECJ, well, no, the ECJ, in relation to the Equality Act. So in relation, that obviously then brings those cases into UK law, and we don't have to then worry about the sunset provisions and dealing with the transfer from as a result of Brexit. But what are some of those changes? So direct discrimination, section 13(6)(b), if the protected characteristic is sex, for direct discrimination, no account is to be taken of special treatment afforded to a woman in connection with pregnancy, and the update is now including childbirth or maternity. In relation to section 18, so protect pregnancy and maternity discrimination at work cases, this now covers unfavourable treatment after the protected period as well as during it, and also where the treatment is because of the pregnancy or pregnancy-related illness during the period, reflecting the principle in Brown and Rentkill. So where in that case where the claimant was dismissed due to incapacity as a result of pregnancy-related illness, that is now something that is covered within the Equality Act specifically, and it also extends the protected period to cover those women whose rights to maternity leave arises under an occupational scheme, so contractual entitlement rather than the Equality Employment Rights Act. Those are both now covered, so there was a slight lacuna in the law where it didn't cover those maternity leave entitlement under the an occupational scheme. It is now included. Perhaps importantly, we have the update to section 19A in relation to indirect discrimination. So where an individual who doesn't have a relevant protected characteristic, they could still bring a claim for indirect discrimination in circumstances where they suffer along people with that protected characteristic from arising from a discriminatory PCP. That case is the case of Ches. I won't attempt to pronounce the rest of it, but that case, as a reminder, there were electricity meters that were installed off a height of around 6 to 7 meters in an area that had a high or predominantly Roma ethnicity, whereas in the other areas in which these meters were installed, they were installed at a height of about 2 meters. So that was considered to be indirectly discriminatory on the basis that if there were issues with those meters, those people wouldn't be readily accessible, being so high up. The individual who made the claim wasn't part of that protected, or didn't have that protected characteristic, but they are entitled now to bring a claim of indirect discrimination. So effectively, it is discrimination by association, but without using those words. And then there is also the inclusion of, when considering disability under section 6 and with reference to schedule 1, paragraph 5A now specifically refers and makes reference to a person's ability to participate fully and effectively in working life on an equal basis with other workers. So previously there wasn't, when considering in terms of the statutory language, when considering disability and what normal day-to-day activities included, that didn't include reference to working life. That is now included. And as some miscellaneous updates, we had the new Vento bans, which will be as of next month. So the lower, medium, and upper bands are there. So a slight increase, I think not as much of an increase as compared to previous years, but obviously, as with everything, the cost of living and inflation, they have been increased. There is the pensions extension of Automatic Enrolment Act 2023, and so that is that needs to say that the DWP are launching a consultation on this, so it doesn't actually come into force just yet, but that would mean that 18-year-olds rather than 22-year-olds would be entitled to automatic enrolment, and it's from the first pound of earnings. And then also, finally, to keep an eye out on the statutory code on fire and rehire, expected in force later this year. Emphasis on being a last resort, and engagement as early as reasonably possible and as full as reasonably possible, and consideration of potentially longer notice periods in that statutory code. But we're yet to see what is going to happen. That brings us to the end of the presentation, so thank you.